Welcome, everybody, to Relate Humanly. We're so happy you're able to join us today. Today, we're going to be talking with Sophia Fraher today. We're going to be talking about some different HR strategies on some different issues that oftentimes comes up in the employment situation. So grab yourself a cup of coffee, cup of tea, whatever is your pleasure. We'll get right to it. Welcome back, Sophia. How are you today?
I'm doing good. How are you?
Living the dream. Today is a great day. So we get to talk about HR strategies. We got you put together, it sound like a list of common questions that we're getting from employers and employees, different areas or hurt points, and we just thought we'd take them out one by one. So what's number one on our list?
Number one is harassment. And I put it at number one because a lot of employees come to you, particularly for initial consultations, and feel very strongly that they have been harassed. And while they have often endured something that's extremely unpleasant, there's a lot within the law about what constitutes harassment and what doesn't constitute harassment that are pretty common misconceptions. So I wanted you to touch on those.
Yeah, and harassment is one of those terms I hear a lot. Toxic work environment, abusive environment. And those all may be accurate terms in the common sense, but within the law, those actually have some very specific meanings. So harassment, kind of a good one to start with, really refers to a work environment that is inundated with comments of a sexist, racist, ageist, ableist, etc. nature that the comments, the conduct is so severe or pervasive that it alters the terms and conditions of the employment, makes doing their job more difficult. Harassment doesn't mean my boss is a jerk. It doesn't mean my manager is treating me unfairly. It means that they are treating you unfairly because of some protected characteristic, or people are telling jokes or sharing pictures or sending text messages of a sexist, racist nature, sexually explicit, etc. And I have to explain this to clients quite frequently. And when I do my sexual harassment prevention training, we go into detail about that a little bit more, um, in a little bit more detail. Sometimes they say abusive or bullying. Interesting thing about the bullying, sexual harassment prevention training requires employers to train their employees about workplace bullying, which includes, sabotaging somebody's work or making their work more difficult. The hard thing to understand is, although we have to train on workplace bullying in and of itself is not necessarily a violation of the law. If I am bullying you because of your gender or your sexual orientation or your gender identity, then that is unlawful harassment. The bullying is the vehicle
Mhm.
that creates the hostile work environment or the harassment. Um, or if I'm bullying you to the point where I'm being physically intimidating, that could create a workplace violence issue, which we talked in a previous episode about workplace violence prevention plans. So bullying in and of itself, certainly we can all agree is bad, may not be illegal in and of itself. So there's that harassment and then the hostile work environment. Again, what does that really mean? It has to do with the work environment being so inundated. It doesn't just mean my boss is being mean. So that provides a clarity?
I think so, yeah. What would you recommend for employees who are feeling very frustrated with their work experiences but aren't necessarily experiencing harassment, and yet it's clearly extremely unpleasant in terms of what their current day-to-day life is?
Yeah. So whether or not something is legally meets the definition of harassment doesn't mean it's something that should be ignored, right? If I'm doing my job and it's being impacted by how other people are interacting with me or treating with me, then that needs to get handled. Um, there's a number of different techniques. First and foremost, you always have the power to say no or stop or leave me alone. Maybe we can find nice ways of saying that, hey, uh, sorry, I don't have time to do this right now. I've got these other things. Removing yourself from the situation, certainly reporting it up the chain of command. Report it to your supervisor or your manager. Well, if your supervisor or manager is the one who's engaging the behavior, well, who's their manager? Who's that next step? Is there an HR person I can go to? I think it helps to be specific about the conduct. If you throw out words like my boss is being unprofessional, or my boss is harassing me, or my boss is being abusive, that doesn't give the person you're reporting it to any idea of what does that really mean. However, if you say, my boss gave me a deadline to have this done by Thursday, today's Tuesday, and they just told me that it's due today. I got all this other work. I can't get that done.
Mhm.
Now you're being very specific
Yeah.
about the conduct. So I would certainly be specific. If you have examples of the things that they're doing or what the person is doing or what they're saying.
Written examples, I might add, things in writing.
Yeah, if somebody's sending you text messages or emails or whatever, Teams messages, WhatsApp, whatever it is, Slack, if you have those, provide those to whoever is responsible at the company for addressing those issues, assuming there is somebody, right?
Yeah.
It's a whole nother issue. If there's nobody within the organization to address it, then you have to go to the outside. You may have to talk to an attorney such as myself or another attorney that represents employees. Um, and the same thing goes with employers. I represent employers. If an employee comes to the supervisor or manager or HR and says, look, I'm being harassed or I'm being bullied, don't ignore it. Get the facts. And don't just assume that you know what the person is talking about. When somebody says this, my manager is being, is harassing me, be interested. Ask them, tell me about that. What is happening?
Yeah.
Get the details. Take notes. Go over it with the employee. Okay, you've said this, this, and this. Is there anything else? Once we know what the actual conduct is, then the employer is in a position to be able to take steps to maybe correct it. So really increasing that effective communication, which I know I teach that a lot, of how do we really be good about communicating these things. Don't, as if you're the employee, don't wait there for 6 months and do nothing about it. And then until you're about ready to quit your job, address the issues early. Same thing I teach employers. If an employee is not engaging or performing the way you want, address it early. Don't wait 6 months. If a problem arises, bring it up. It doesn't have to be a complaint. It can just be, this is what's happened and this isn't working for me, or this is making it more difficult for us to accomplish our goals, and have that
Yeah.
conversation.
Yeah. Two other really important things with harassment that I just wanted to mention is for 5 or more employees, you can do harassment prevention training. It's something that we have offered before. But yeah, it applies to most California employers. And then also it's important to maintain a zero harassment prevention policy in writing, preferably in your employee handbook, which we did another episode on. But yeah.
Yeah, the training, yeah, if you have 5 or more employees, you have to do training every 2 years. And it's 1 hour of training for non-supervisory employees, and an additional hour of training for anybody that has any supervisory or managerial authority. And the two trainings are similar. There are free options. I believe the California Civil Rights Department has a free training. I'm not going to say it's the most exciting thing. There are online versions. Cal Chamber has one of them, BBSI, other HR companies do them. They're packaged, so they're not necessarily company specific. I do think live trainings are best. If you can't do live, I think a Zoom is fine, but if you can have it be a little bit more interactive, I definitely believe getting some interaction can take a 2 hour training and actually make it so you stay awake during the whole thing. Because what's the sense of doing training if all you're doing is checking the box, then that is not an effective way to stop harassment. If we're actually doing training that's intended to get employees engaged so they understand what it is and they have tools, that's going to be the most effective.
Item number 2, is another very common misconception, which has changed, a lot in recent years, about independent contractors. And speaking of soup agencies and the like, the ABC test,
Yeah.
if you would like to touch on that.
Yeah. So, very brief history. Back in the day, when I first started practicing law, the main test we used in California was what we called the Borello test. The Borello case came out with one primary issue or test, which is the control test. And then there's like 11 other factors. And those are very similar factors to what the IRS uses and what might be used in other jurisdictions. 2018, the California Supreme Court was interpreting the phrase suffer or permit within the wage order and decided to adopt a new test. It's called the ABC test. Those things that are within the ABC test are factors that are already within the Borello test, but the ABC test is you have to answer yes to all three of these. And they are things such as, is the employee doing work outside of the employer's normal business? Does the employee have their own established business that they're performing? Of course, are they free from control? And it was very strict. So essentially, I, as a law firm, occasionally I have a conflict with, I'm booked in two courtrooms at the same time. So I might ask a colleague, hey, can you cover this hearing for me? You just need you to show up and I'll pay you for it. Very common. Well, under that strict ruling of the ABC test, because that's work that I do, that person is my employee for that purposes. Create all sorts of havoc. So in 2020, the California legislature officially adopted the ABC test as the test, but they also included a lot of exceptions. And a lot of those exceptions now, like they have attorneys, um, marketing people, certain marketing people, uh, HR people, and there's a whole bunch of other professional exemptions. And like, I think if you count them up, there's like 130 different exceptions to the rule. What's important to know is the exception, if you meet one of those exceptions, that doesn't mean the person is an independent contractor. It just means now you're going to apply the Borello test. You're still going to use that as the backbone. And all of the factors for all of those different exceptions, or I would say most of the exceptions, they're still proving different portions of the Borello test. So those are things like, are they providing their own tools? Do they have a licenses that are required to do business licenses, professional licenses? Do they have authority to hire, fire, or bring in their own employees? Do they have a operation that is separate from where they're doing the work? If they're coming in and doing work, and it's still your the type of work you're in the business to do, but they're providing the services to one of your clients, are they doing it in your name, or are they doing it in their own name? All of those factors can change whether or not they would be or would not be an independent contractors. What I usually tell people is most people are, the default is you are an employee. And it's the employer's burden to prove that somebody falls outside of that. And it's a pretty high burden. So don't just assume that this person, I call them an independent contractor, so that means they are. It's much more difficult than it used to be.
Yeah, for sure. Kinda going off of that, there is some overlap, but the next topic was, exempt versus not exempt employee status, and we can do it with specific regard to caregivers, and also as a segue, if you'd like to touch on caregivers and independent contractors as well, that would be an interesting little tidbit.
Okay, so that's a whole lot there. So we got exempt versus non-exempt, issues with caregivers, and then independent contractors and caregivers. So I'm going to break it down one at a time. Exempt versus non-exempt has always been and will continue to be one of the most common mistakes employers make. The baseline, certainly in California, is employees are entitled to overtime, typically if they work more than 8 hours in a day or more than 40 hours in a week, and they get double time if they work more than 12 hours in a day. And then there's seventh consecutive work days in a work week rules. So they get overtime. Exempt means they are exempt from the overtime rules. And there are three primary exemptions. Well, actually, technically four primary exemptions. Then there's a whole bunch of offshoots. The primary exemptions we look at are the professional, administrative, and executive exemption. Those are kind of the big three. And then there's also computer professional. For the big three, all three of those require you to pay the employee a minimum salary of 2 times minimum wage for a 40-hour week. It doesn't mean just paying them 2 times minimum wage and paying them hourly. You have to guarantee them a salary so that whether they work 1 hour or 160 hours in the work week, they get 2 times the current minimum wage every week for a 40-hour work week. So even if they're a part-time employee, you still have to pay them 2 times 40 hours at minimum wage.
Mhm.
2 times minimum wage times 40. You get what I'm saying. And you have to guarantee them that salary every single work week. You don't have to pay them every work week. You can pay every 2 weeks or twice a month, but they have to get that same salary regardless of the number of hours they worked, with some very few exceptions. The salary part's easy. The harder part is for each of those exemptions, professional, administrative, and executive, you have to meet certain requirements. For the professional exemption, I think there's like 7 stated different exempt positions: attorneys, architects, CPAs, doctors, a couple others. Almost all of them require some type of licensure by the state. There's a subcategory within there which is called the artistic or the learned exemption, which can apply. Artistic would be people like an artist or a writer on a sitcom or something where you're using your artistic abilities. The learned exemption is somebody that is working in a field that requires a higher degree, meaning higher than a bachelor's. Sometimes you can substitute that with very significant experience in the workplace, but usually is dealing with areas in scientific areas. So you might have, say, an engineer who doesn't fall within one of the other exemptions, but they're a licensed engineer, and that could qualify in there. The executive exemption requires the person to supervise 2 or more employees. Not one employee, 2 or more employees. And generally they have to be in charge of a particular area. And supervise doesn't mean they just get to tell them what to do. They really should have authority to hire or fire, or at the very least, make recommendations to hire and fire that the employer will typically try to follow. So it's really your higher level management, not just a lead person.
Yes.
And then the administrative exemption is one of the more misunderstood exemptions. In fact, I would say employers get it wrong, attorneys get it wrong, judges get it wrong. The California Supreme Court has flip-flopped back several times on what it means in different contexts. It can be a lower level person, but they really need to be working on projects, important things, and they have to have the ability to exercise discretion and independent judgment about matters of consequence. So take you, Sophia, you're a paralegal.
Yes.
You do legal research, you meet with clients, you help analyze things, you maybe help some of my clients create their workplace plans, prevention plans. You do those things that are similar to what an attorney does. But because you can only do that under my supervision, you cannot practice law. Almost every paralegal is going to be non-exempt, meaning they should be paid hourly and they should get paid overtime. Even though you're making important decisions and you're exercising discretion and judgment, it's not at the level that's needed to qualify for the exemption. So that's one that's make a big mistake. And then I mentioned big 4. The fourth one is the computer software engineer, also couldn't include hardware. And I only mention that one different because it's the weird exemption that you can actually pay somebody hourly and they can still be exempt. It's really limited to software engineers, people who are writing code. There can be some hardware people and there are some nuances, but it does allow you to pay them hourly. Or you can also pay them a salary, but the salary threshold for the computer professionals is significantly greater. I don't have it on hand. It's like around $130,000 a year.
Mhm,
Hourly rate, something like 50 or 70 bucks an hour. It went up really high and then it went down. It's kind of gradually increasing it, and it changes every year.
mhm,
So that's the other one. Then there are these little smattering of ones that I don't come across: ski lift operators, um, camp counselors, sheep herders, irrigators that are kind of very industry specific. But my very first case, that when I first sent out my first demand letter, when I was in law school, I had this great case. I had the pay stubs that show my client was working overtime. And I sent out my demand letter, and my opposing counsel pointed out, yeah, here it says irrigators, they're exempt from overtime. Do your research, look at your wage orders. So that's exempt versus non-exempt. I say again, you start with the proposition that everybody's entitled to overtime and is not exempt. They're non-exempt from overtime. So pay them hourly, pay them overtime, know what your requirements are so that we can make sure we're not violating the law. Paying somebody a salary when they are not exempt from overtime, when they're supposed to get overtime, is very dangerous. That's actually a good segue from the exempt versus non-exempt to caregivers, and also ties in with the independent contractor. When I started working with families, professional fiduciaries, trusts and estates, care agencies back in 2008, the law was different. But a lot of people were still having problems with it. The standard back then was, oh, we hire these caregivers as independent contractors and we pay them a daily rate or a weekly rate and we're all good. Well, neither of those were good. But in 2014, it got much worse because the law changed pretty significantly. And let's just be very clear: caregivers rarely, if ever, can be independent contractors. There could be a situation, it's very difficult for it to be that way. They'd have to have their own business and all these things. And that includes having to pay them overtime. Caregivers are a bit unique for most caregivers. They're what in California, we call them personal attendants. That's the official way that the Domestic Workers Bill of Rights calls them. But to be a personal attendant, their primary job has to be um, supervising, dressing, or feeding somebody who cannot care for themselves as a result of age or disability. And there's a lot to impact there. And we can do, in fact, we should just do a whole episode on caregivers.
yeah, we should.
The basic thing is what I'm saying is you need to pay them hourly. They typically get overtime after 9 hours in a day and or 40 or 45 hours in a week. I say and or because it depends on, you got to drill down a little bit more. Do they fit the federal companion time after 9 hours a day instead of 8 hours in a day? And there's no double time. So the overtime rules are slightly different if they meet that personal attendant exemption. If you hire me as a caregiver, but I spend most of my time as a chauffeur or doing laundry or house cleaning, then that personal attendant exemption may not apply, and the normal 8 hours in a day, 40 hours a week would apply. So don't treat them as independent contractors, and always pay an hourly rate and know what the overtime rules are so that you can actually pay them overtime when you
Yeah.
require.
And in order to know all of these things, you need to keep a record of how their hours worked, which is the
Yeah.
most important.
Yeah.
Yeah.
Always keep track of hours worked for any hourly employee. Caregivers, again, they should all be paid hourly. But even outside of the caregiver industry, in regular hours, if your employee is not clearly exempt from overtime, you have to track the hours worked. This even includes if you pay somebody by the piece, like if you're paying them based on the number of widgets they create, whatever it is, you have to keep an accurate record of the hours worked. So always clock in, clock out, clock in and out for their lunch breaks so that we know when they get their lunch breaks. That's all kind of our best practices.
Again, in specific regard to exempt or non-exempt status, wage and hour violations, rest and meal break violations, waiting time penalties.
Yeah. So one of the biggest areas for litigation, one of the areas where employers are more likely to make mistakes is in the wage and hour realm. So, and I love wage and hour issues. I've always enjoyed it. My first trial was a wage and hour trial while I was still in law school. I got to do a 2 week bench trial. It was great. And I love those. There's some very interesting issues in there. And it's an area where people make a lot of mistakes. Biggest mistakes, treating somebody, paying them a salary when they should be getting paid hourly.
Mhm.
Um, Ensuring that we have rest and meal break policies in place that are being followed. Employees are entitled to a paid 10-minute rest break whenever they work 3 or more hours. And really, for every 4 hour block, they should get a 10-minute rest break in the middle of that block. So work 2 hours, take a paid 10-minute rest break. They don't have to clock out, but they need to get the break. And then they work another 2 hours. And then guess what? They get their lunch break. The lunch break has to be a half hour uninterrupted. It does not have to be paid, but we do need to keep track of those. We do want them to clock out and
Yeah.
clock back in. There are some exceptions. There are times when you might be able to have an on-duty meal agreement because of the nature of the work, but those are pretty limited. So a general 8 hour workday would be work 2 hours, get a paid 10-minute rest break. Work 2 hours, get a half hour lunch. It can be longer if you want. Work 2 hours, get another 10-minute rest break. Work 2 hours, go home. That gets you your 8 hours a day, and it makes sure that you're getting all those breaks.
Mhm.
So absolutely, we need that as a policy, but we also need to ensure it's enforced. When you get your time records back and you're entering that into your payroll system, is there a record of them taking their lunch break? If they didn't get the full half hour lunch break, ask the employee, hey, I noticed you only took 28 minutes for your lunch break. Did something happen to interrupt your lunch? No, I just finished lunch. I wanted to get back early. Oh, okay. Now you make a little note. I had the conversation with Sophia. She said nothing interrupted her lunch. She just wanted to get back to work. That's fine. Because what happens is the employee leaves and all of a sudden they go talk to an attorney and, oh, I never got my lunch breaks, or they were always interrupted, and we don't have the records to back up the fact.
Mhm.
Almost every single demand letter I get, almost every single lawsuit that gets filed that I've seen recently in the employment arena includes rest and meal break violations.
Yes.
Final pay, you mentioned that pretty simply. When an employee quits, you have to pay them within 72 hours. If they give you 72 hours advance notice, you have to pay them on their last day. If you fire somebody, you have to pay them on their last day. So if you're thinking, hey, I need to fire Sophia today, I'm not firing you
Aw.
today.
Okay,
If I'm
thanks.
going to fire Sophia today, I better have her paycheck ready. An alternative is I can say, okay, well, I'm not going to fire her today, but I'm going to fire her tomorrow, but I'm going to have to pay her for that. And there's reporting time pay where I have to pay you for at least half your shift. You can't just say, oh, I can't get my paycheck so I'm going to suspend you today and then I'm going to fire you. You'll have the check tomorrow and pay you first thing. I mean, be prepared to pay for the full day, quite frankly. And there are pretty stiff penalties. If I don't pay you, your wages continue as a penalty until I do, up to a maximum of 30 days. So that's your daily rate multiplied by each day of the calendar. It's not even your work days. It's Saturdays, Sundays, holidays, all that's included. And it goes towards that penalty. And I've had many cases where those penalties exceed what the actual wages are owed. So those are kind of the big wage and hour that I would say the big three: not paying overtime, miss not correctly applying the rest break and meal policy and keeping track of those, and not paying those final wages on time.
Yeah, for sure. Yeah.
So that's a lot. I mean, we've covered a lot. These are just some of the basic issues. I'm sure we'll set up future podcasts where we can talk about some of the other ones. If you have a specific question, go ahead and hit it in the comments, or a specific topic you want us to address. Send us an email. You can always reach us at nuddleman.com, of course. But you can always just do a comment in our YouTube channel, and we'll do what we can to answer or address the questions in future episodes. Sophia, any last words before we let you go?
Nope. Bye.
Have a good day.